Hi, good afternoon if you're on the East Coast. Good morning if you're out west, particularly if you're one of our listeners that's way out in the Pacific and the islands. We're always glad to have everybody on board. You are listening to Immigration and Higher Education as part of the Higher Ed webinar series produced by Thompson Coburn, LLP. Always, like I said, glad to have everybody back. There's certainly a lot going on in the world today, and we're going to try to talk about some of that. But before we get into it, just a little bit of housekeeping, and that allow some other folks to jump on the line here. For starters, as you know, if you've listened into our Higher Ed webinar series before, all our programming is approved for continuing legal education. So if you are an attorney and you are looking to get CLE, hopefully you're in luck. This webinar is CLE accredited in California and Illinois for an hour of general CLE credit, in Missouri for 1.2 hours, actually. We, meaning Thompson Coburn, award CLE based on attendance for the entire 60 minutes. So from the time you jump in to when you log off, keep in mind the clock is running, and you may be required to click a pop-up screen or two to reflect your continued engagement. If you are an attorney in one of those jurisdictions outside of California, Illinois, or Missouri, you may still be able to get CLE credit, but you'll have to work with the state to supply them the information and get that credit awarded. During the presentation, you can submit questions through our Q&A widget. Actually, if you look down at the bottom of the screen, we have a number of widgets, and they each serve a different function. Typically, in our webinars, if you've listened in on the series, we will wait until the end and then take Q&A. But today, and one of our presenters, Kelly Simon, will talk a little bit more about this in a minute, but we're actually going to break up the presentation. We, on the front end, are talking about the topic of the day and of the hour even, COVID-19, coronavirus. And we thought we would just stop at the end of the segment where we are talking about that and go ahead and take questions. And if we fill up the rest of the time with those questions and answers and stick to that topic, that's okay. And we can always come back and get to the rest of the agenda in a subsequent webinar. Also, the resource widget at the bottom of the screen. So we're going to talk about coronavirus, and specifically we're going to talk about it through the lens of immigration, right? Whether that be faculty, staff, or students. But we acknowledge it's a very broad topic, right? It's affecting all different industries, not just higher ed, in lots of different ways. So our firm actually has produced for a wide range of our clients some best practices around coronavirus that aren't designed specifically for higher ed or immigration, but are just general for any business. Some thoughtful things that you may want to do as you're working through this time. And we've included that best practices document in the resources widget. So please take a minute and pull up the resources widget and print out that document, download it, print it out. We think it will be helpful for a lot of different people, no matter what you do or what industry you may be in. The help widget is, like it says, there to help you out. There are some answers to common technical issues if during the webinar you find you're having some difficulty. And finally, we always have, when we send out information following the webinar, actually even during the webinar, you can go down and fill out survey on the webinar. We really take these seriously. We review them after every single one, and we really try to make every subsequent webinar, every webinar better than the one before it. So if you have time, please do fill out the survey. With all of that being said, let's get moving. Thompson Coburn's a law firm, by the way. Sometimes people tune in and don't appreciate that. We have nearly 400 attorneys across a bunch of different offices in places like Washington, D.C. and Chicago, but we are based in St. Louis, and that's where we're all sitting today. My name is Aaron Lacey, and I'm the chair of the Higher Ed practice and also the host of this Higher Ed webinar series. So you tend to hear me every time, but the good luck for you is that I'm not always the presenter. So one of the wonderful things about this is that we have lots of folks who work with higher ed in our firm and who are able to take part in the series. So let me just take a minute to introduce those, and we have some pictures at the very end of the webinar, but I'll go ahead and talk a little bit about your presenters today. The chair of our immigration practice is Kelly Simon, who is sitting just to my right and does all things immigration for lots of different industries, but also spends a lot of time working on immigration matters for institutions of higher education, including a couple pretty large ones right here in the St. Louis metro area. And I know, Kelly, that you've done a tremendous amount on the faculty employee side, but also we have interfaced before too on issues involving institutional eligibility to participate in an SVP program or student, international non-immigrant student type issues as well. So lots and lots of thoughts about immigration, and as indicated earlier, when this presentation was originally conceived, was going to talk about some of those more, I'll say, routine issues, not run-of-the-mill, but routine. And then in the last 2 or 3 weeks, the COVID-19 sort of became what it is, and this hour has morphed a little bit into a conversation focused more on that particular issue. We've also got Amy Oslica, did I say that right?
Yep.
Oh, boy, the odds of me getting that right were so low. I'm very pleased with myself. Who is one of our human resources attorneys who does lots of different work in that area and has been thinking a lot about coronavirus. So as this presentation sort of turned more towards that topic, we thought it would make a lot of sense to get somebody in the room who's been working with different organizations and their HR vertical and thinking about how to manage some of these issues. And then finally, sort of a surprise guest here, we have Scott Goldschmidt in the room. Scott, a week and a half ago, was the Deputy General Counsel at Catholic University in Washington, D.C., and has just this week joined our firm, so has spent time recently thinking about this from the in-house perspective, and also we thought it would be nice to have him in the room today as we're talking through this as someone who has spent, the last 8 years at a large private nonprofit university dealing with things inside the university, and certainly appreciate, Scott, you being here and your ability to add that in-house perspective to the conversation. We have other folks who work with us, all those shining faces at the firm and who do different things in higher ed. And I'll just pitch real quickly, we do have the higher ed webinar series. This is part of that. Next month, we're going to be doing intellectual property. In May, we're going to do cannabis and higher education. Pretty interested and excited about that topic. A lot of interesting things happening there as well. And again, maybe we'll do a follow-up. We usually run our webinar series along with the academic year, but what that means is we don't have any planned content for the summer, which gives us a little flexibility, and maybe we'll do a follow-up on immigration if we don't get to everything today. So with all of that being said, I will hand the mouse over here to Kelly to talk about the agenda and get us rolling.
Oh, thanks, Aaron. So as Aaron mentioned, we had conceived this webinar months ago, and we're going to focus on kind of the evolving areas of immigration law that impact higher education. And then COVID-19 happened, and so we are going to lead today with a slide deck on COVID-19, talking about immigration, HR, kind of other matters. We're going to pause for questions on coronavirus, and then and the appropriate responses. And then when that is over, we will move on with the remainder of our time to any to our other topics. The initial conception of the webinar. So to get started, we're going to talk about COVID-19 and immigration. Top of mind, especially this morning, is how the U.S. response to the disease and its public health challenges is impacting the actual entry and admission of foreign nationals to the U.S., be it your students, sponsored employees, faculty, researchers, scientists, other individuals that the institution sponsors, and also, frankly, U.S. citizens who are traveling abroad. Yesterday at this time, there were 2 bans. It was China and Iran, and by last night, it had encompassed the Schengen nations, which is almost all of Europe with the exception of the United Nations. And to get started, the ban is restricting the travel from those areas. It does not apply to U.S. citizens or U.S. permanent residents, although there are reports this morning that Vice President Pence has said any U.S. citizen and permanent resident returning from Europe is going to be subject to a 14-day self-quarantine. So just because a U.S. citizen can get back to the United States doesn't mean they will be getting back to their normal lives. They will be getting back to quarantine. Other reports this morning are just kind of the exponential increase of tickets home. There are reports of people logging on to change their ticket and literally watching the price of the ticket go up by thousands of dollars through the course of buying the ticket. So while those U.S. citizens and permanent residents will be readmitted, the cost may be higher, not just in money, but in what they're returning to, which is likely to be a quarantine. The ban also doesn't apply to the parents, legal guardians, and siblings of some U.S. citizens and permanent residents. And there are a couple other even more kind of narrow exceptions to the bans. But for the most part, if you have, for the most part, this is a kind of place we are where people shouldn't be leaving the United States if it's important for them to get back and to get back easily. This slide just goes through the member nations that are subject to yesterday's ban. For institutions of higher education that have faculties ready to do their research, to go to their international conferences, the conferences are probably canceled. But, this is sort of a time where no one should leave unless they truly have to. And there needs to be really careful consideration about the risks and the costs and benefits of the travel. Because I have to say that 2 days ago, if somebody had asked me, we have a faculty member who's going to Germany, that's okay, right? I would have said, yeah, what are the chances of travel from Germany being restricted? And that, radically changed overnight. So if within 24 hours, permanent resident or within 24 hours, foreign nationals in Europe can be prevented from entering the U.S., there's no country that's completely safe from having a ban like that imposed, and you don't get a lot of time when the ban goes into effect, right? It was announced yesterday. It'll be in effect by tomorrow.
And Kelly, maybe it seems to me, and you've hit on this, that that's one of the things that has really changed in the last 48 hours is, whether and to what extent this pandemic will really impact the United States and, in terms of the disease itself, economic, all of these things we don't know, and the difference between the beginning of the week and today we may not know much more than we did then. But one thing that has become very real are the steps organizations are taking and the government is taking. Folks are canceling things. There's, the NBA suspended its season. March Madness is going to be in front of empty stadiums. We've had conferences that have been canceled. That we have clients who cancel things that so it really seems like, to your point, at this stage, if you've got faculty, others who are talking about international travel, the likelihood or possibility that they could get stuck for a long time is real, and it's beyond the stage of maybe, but it's a serious consideration.
And it is completely unpredictable. Is really where we are right now, right? Like, I'm not a public health expert. I can't tell you the public health implications of any of this. But as an immigration lawyer, where part of our job is to see the future, if you can't tell a German citizen or a French citizen you're going to be able to get back, you really shouldn't be telling that to anyone. And right. So what we've really seen is the flip from you can go, most things work out fine, to you should stay. Do you really need to go? And that is different and is going to be a lot of ongoing discussions, across the country with lots of employers, not just higher ed. Yeah. And of course, the other huge set of stakeholders impacted by the coronavirus are your students, the international student population who may already be in the U.S. but really can't leave for fear of not getting back. as well as students abroad who just can't get back. And so this is an area that there is likely to see much evolution and much change in the coming days. This week, the Department of State released information to its partner institutions, reminding them about what steps USCIS can take to help a student who may have unforeseen consequences, unforeseen implications of the travel bans. And it includes, there are times when F1 students who can't usually get work authorization can be work authorized because of extraordinary circumstances. People can change status into different statuses if there's a problem with them maintaining their F1. There exists the notion of special student relief, which is kind of a more global, broad-based authority that immigration has to kind of tweak the terms of traditional F1 student visa terms. That hasn't happened yet, but, it's certainly an area where it could. And so as this develops, the offices of international students and scholars will have more and more questions about what to do and what their students should do. Every student is going to have their very, very specific personalized facts, which are going to go into what can help them. And so, at an institutional level, we want to walk a careful line between providing information that's helpful and not over-providing information to a student when you don't know all the details of their circumstances. But it is clearly an area that there will be great evolution. And it's also relevant to note that it wasn't USCIS that kind of made this announcement. It was the Department of State referencing the things that USCIS could do. So there, hopefully will be more to come.
So one of my questions for you, and I feel like this always comes up when you're an immigration attorney in the school setting, but is walking this careful line, between providing useful advice to students and employees and not becoming their attorneys and giving them legal advice. And I have to think right now on college and university campuses, you've got lots of students and faculty and staff coming to the schools, essentially soliciting a form of legal advice, saying, tell me what I should do.
What should I do?
And so, I don't want to digress too much from the deck here, but I think it strikes me as really important for schools. If you're sitting in and maybe Scott, you can speak to this too, but if you're sitting in house right now and you've got students and faculty and staff coming to you saying, what should I do? How do you answer that question? How do you, prove helpful while being mindful that you don't want to suggest to them that you might be their attorney or counsel?
Well, I think the first and foremost thing that every employer or institution of higher education or anyone involved with this, when asked that question for anyone, is we have to follow the rules. I actually think this is an area where a lot of desperate students could be desperately trying to get any help they can. And so as an institution of higher education, as a sponsor of international student visas, your first commitment is to upholding the rules of the program, full stop. And then the next is, what can you do for this student? And it may be, are you shutting down your housing? Is there a way to shut down housing and still have a place for your foreign national students who can't leave to live? That could be possible, right? I think it's keeping what their needs are top of mind, because when they come to you asking for help, they're actually asking for help in all the
not
areas.
Just legal advice.
It's not just life. Legal advice. It's like life. Like, where am I? If you're shutting down the dorms, where am I going to live? Right. If I go, will I be able to come back? And the answer might be you don't know. And there may be times when a student does have to go in the midst of this crisis. I don't think we're there yet. We're in the middle of a semester, but but yes, that is a very careful line for people
Right.
to walk.
And I also think there's an important distinction between legal advice and legal information. So when I was at Catholic University, we're always careful not to really listen to too much of the particular facts of a situation, but students, especially foreign students, don't have much familiarity with U.S. law, U.S. programs, and really wouldn't know where to find the information. So to the extent that you have a lawyer in your school or someone trained to know where these resources are, aggregating guidance from FSA for financial aid, OCR for discrimination, USCIS for immigration, and presenting that information in a way that could be helpful to the student could at least give them a starting point to either get the help themselves, advise them to get an attorney if it's really specific, or kind of a next step to go from there. But to your point, Aaron, we definitely don't want to be advising, just helping as best we can, because they are students and we really do want to care and do the best we can for them.
All right, and then kind of the other aspect of student sponsorship is dealing with the student exchange visa program and the many administrative and very practical obligations there are to report what programs your foreign national students sponsored students are involved in. And on Monday, SCVP released its directions on how to inform them of operational or curricular changes within 10 days of the decision. The appendix 1 of it is where they lay out step by step what you need to tell us within these 10 days. If you're moving to online instruction, they want information on the mode and classroom setting. Are you in computer labs? Are students doing this with their own laptops? How are you going to provide oversight for the students? That is always the biggest issue with online instruction, is how do you know they're doing what they're supposed to be doing if they're not on campus, with you. The programs and classes impacted, and how long you think the online instruction is going to last. The other piece of it is if, the Department of Homeland Security, immigration is all about knowing where people are supposed to be. Location and geography is critically important. So if you're changing the physical location of where students will be studying, they want to know how the school is going to offer the instruction, how is oversight going to be provided, how is the school providing DSO services to students, how do you know everyone is ensuring that they maintain a full course of study? And again, how long the alternative instruction situation is going to last.
You may not have good answers to some of those questions, right? Schools are going to have to do the best they can, right?
Right, and I think that's the point of having that's why they release this information, is because they know that this is a very evolving situation, and public health directions change quickly, and you want to provide the most information, the best information you can.
And thinking ahead as a school or university, and hopefully this is something that you guys are already thinking or have thought through, but because this is such an evolving situation, you want to make sure that your emergency management crisis communication team is up and running. Everyone is clear on where decisions go in terms of closures, move to online, academic programmatic decisions, and then how to clearly communicate updates, resources to your students, be it a website, telephone system, alert system, and things like that.
All right, so we are going to turn to some of the kind of HR consequences and implications of coronavirus. Amy?
Hi, everyone. In our practice, in the Labor and Employment Practice Group, the past week has been pretty wild, given what's going on with coronavirus. And so Kelly asked me if I would come in and kind of synthesize the information that we've been giving to our clients related to human resources and what you can do to be proactive and to respond to these issues. So I've got about 5 big points that I'm going to go through. And feel free, you can use the Q&A function if you have any questions as we go through. So obviously, and we are hearing this a lot from the CDC, but the biggest thing that we can all be doing right now is preventing the spread and controlling the spread of the virus. So there are a few parts of this and what we can do, and one big one is encouraging our employees to stay home or self-quarantine if they're ill. And I'll discuss some of the implications of this as far as your paid time off policies go, sick leave. But if an employee feels ill, we want to encourage them to stay home, maybe even requiring employees to stay home who are returning from places with confirmed coronavirus cases, asking them to work remotely if that's possible, particularly focusing on the top 5 places that the CDC has identified, being China, Iran, South Korea, Italy, and Japan. If you notice that an employee does have flu-like symptoms, you can consider sending them home until the employee is medically cleared to return to work. One thing I would say is that if that is a route that you go down, we would recommend that if an employee is going to be required to stay home at the employer's request, the general preference is that you would still compensate that employee for their time, especially if the employee indicates a willingness and preparedness to work. The biggest issue here is just avoiding unintentionally encouraging infected employees to still come to work. You want to consider canceling and postponing unnecessary travel, as we've discussed, meetings, large gatherings. I'm thinking of my time at school and campus tours and big admissions events. Think about how these events can be shifted online, if they can be, if they can just be postponed. And then making sure that you're effectively communicating with third parties, prospective students, parents, vendors, about the importance of staying home if they're sick. So how are you going to encourage these employees to stay home? And you're going to need to look at your current policies to see how you can enhance them to address these concerns. So some considerations that we've been talking about in our group are relaxing requirements for physician sign-off for sick day qualification. If you have a policy that an employee needs to bring in a note from a doctor, they might not be able to get in to see a doctor right away nowadays, and that might be prohibited. So maybe relaxing that requirement, temporarily enhancing your remote work policies, especially for employees who are exhibiting any flu-like symptoms, broadening your current PTO policy to enable employees to take off work for events like childcare, facility closures, school closures, that sort of thing. Another issue that's come up is whether or not your state has a paid medical leave insurance program. There's been a number of states in the past year, actually, few years, that have passed these paid medical leave, and it's similar to FMLA, but it is provides for portions of wages to be paid by the state. It's usually funded by a payroll deduction. So you can see if you're in California, New Jersey, Rhode Island, New York, DC, or Washington, they've passed those kinds of laws, and potentially your employees who have had to take off work may be able to benefit from some wage replacement. The next thing that you can do is just generally treat all your employees with respect and consider all of the federal and state laws regarding discrimination that could apply to you. The biggest thing here is going to be the ADA and associated state laws. Employers need to make sure that they're following ADA guidelines before making medical inquiries or requiring medical exams of their employees. If you want to require a medical exam, it needs to be job-related and consistent with business necessity. What that means is a number of things, but it would include an employee who would pose a direct threat due to a medical condition. So with with that being said, all of these situations are unique, and you're going to want to work with your in-house counsel to determine whether or not you're comfortable that these medical inquiries and potential exams would be in compliance with those laws. And then as far as that goes, you also want to make sure that you're ensuring the confidentiality of any medical records that you're receiving from your employees.
And I know, I'll just jump in real quick, Amy. I know that some organizations have obviously a lot of federal agencies, USCIS. For those who do like I do, Federal Financial Aid, FSA, have been providing specific resources in the last 3 or 4 days. And my recollection was Office of Civil Rights actually at the U.S. Department of Education put out some information. Because to your point, when you start thinking about how you're managing your relationships with students, employees, whether it be under disability, or I think there might be some concern about prohibiting entry of certain classes from certain countries and nations, right? That could get into
protected class.
Yeah, right.
Very, very quickly.
Scott, you said you had a chance to look a little bit at that OCR guidance, right?
That's right. And to your point, the OCR specifically pointed to Chinese ancestry and Asian Americans as having reports of allegations of discrimination and disparate treatment based on illegal reasons. And the Assistant Secretary reminded schools of their obligations under federal law to prevent that from happening and ensure a safe and non-discriminatory environment for all students.
It's plan your work and work your plan.
Yeah.
Right? Like whatever the plan is, whatever the policy is, has to be applied equally to everyone, all of your employees, regardless of, and that is to protect everyone from targeting someone because of a protected characteristic.
Yeah. So I guess I'm a very practical person, but in my mind, the short answer here is it's tricky business, but just because you have a pandemic does not mean that civil rights get thrown out the window. There is going to be a tension between the two, potentially, particularly where you have certain countries where something like a pandemic may be far more present. And schools just need to be mindful of not just federal discrimination laws, but state discrimination laws, city discrimination laws, et cetera. And if you are concerned that some policy you may be looking to pursue might have a prohibitive impact on a protected class, which is legalese for, might discriminate against folks on the basis of race, color, et cetera, all those things that are in your non-discrimination statement, you should talk to your attorney and be mindful of that, because again, it's not a free pass to discriminate. Sorry, Amy.
Yeah. Well, I would say that goes really is a good segue into my next point, which is making sure that you've formulated a plan. And I'm guessing that most of you have already done this, but as we've been discussing this morning, obviously everything is really changing even over the past 24 hours. So make these internal plans, make sure that you're staying up to date on the information, and then effectively communicate these plans to your employees. Communication is key, and making sure that your employees know what the plan is very important, because then they're going to have clear expectations. They know what your expectations are of them when it comes to sick leave, time off, working from home. You want your employees to know what you want from them and what they're permitted to do. Frequently updating your employees regarding your plan. Obviously, with everything changing, your plan might be changing, and you want to make sure that your employees know what's going on. Make sure that your employees know that they can reach out to human resources with their concerns. One thing that we have been discussing is that you should encourage employees to advise HR confidentially if they believe or learn that a fellow employee has contracted the coronavirus. That way that you can address the situation and be proactive. And like everybody's been saying, encourage good hygiene habits, washing your hands, sneezing into your elbow. I think that you've probably heard that way too many times to count in the past week, and me telling you again is maybe borderline annoying, but it's a really good practice, and as much as you can reiterate to your employees that that's what they should be doing, you should. And I will pass it back to Kelly.
Well, and, clearly COVID-19 is touching every area of higher education. So Scott or Aaron, what other things are you thinking about or are you counseling about?
I'm happy to start, and this is for sure not an exhaustive list. Just one more thing to add to Amy's thought. The House recently just passed their version of the multi-billion-dollar Corona package, and in the House's version, there are some protections for employees that use sick days, so you can't be penalized for using sick days. So I have no idea what the Senate will do or the President will sign, but at least be aware that that could be coming down the pike. In terms of other specific higher education issues and concerns, just really briefly, because it's not a one-size-fits-all and everyone has responded differently based on everyone's circumstances, but for students, really generally thinking of big issues down the road like graduation and final exams, how are the ideal plan, what are the contingencies, how do you deal with current things to get to graduation, like clinical experiences and other academic requirements that may not easily translate online. Is your counseling center available for students that might have issues, and can they be contacted remotely? What about accessibility issues for online learning? I know these platforms are new for a lot of schools, and have they been tested, and is your software currently up to date? Do professors know that videos need to be captioned and PDFs need to be relayed a certain way? What about the issue of a quarantine, if for those of people that are still having students at residence halls, making sure there's a plan in case there is an infected. In case a student does have a presumptive positive or is positive for coronavirus, how do you deal with that? And then what are your obligations to inform the campus community, both in a public health situation, but also taking into account student privacy issues, FERPA and HIPAA and all the medical confidentiality issues that can come with that. In higher education, Twitter, at least parents that I've been seeing, refunds are a big concern. So not only the academic, the financial aid issues, but how you deal with room and board and meals, especially when you send people home. I know you have contracts with your vendors. They're probably not going to, depending on how they're written, take a lower payment, but is it a good practice to give at least some kind of partial refund? Looking at your contracts, a lot of schools have conferences and camps and things that are set up. Just making sure you talk to counsel and understand, do you have a termination for convenience clause? Do you have a force majeure clause? Is your force majeure narrowly drafted for impossibility, which may be tough to hit, versus something like impracticability or commercially inadvisable or other buzzwords like that? And last, looking at your insurance, and I hope everyone's talked to their broker by now to understand if you do have pandemic coverage, which is rare, but also business interruption coverage, and what things you need that to kick in. Is it physical only? Is it a certain number of days that need to take into account? And do you have to give notice to your broker in order to kind of start the clock there? So I'm happy to talk about any of those or more, but that was the kind of list that I came to when I was trying to figure out how what we would want our leadership to think about, at least going forward.
Yeah, and for the folks who on the line who aren't attorneys, I mean, I actually had this conversation yesterday with someone, and I said something about force majeure, and they said, "Okay, can you speak some English?" And I said, "Yes." So, this is the clause in your contracts that says if you have something like an act of God, right, hurricane, tornado, flood, you can get out of the contract. And it is actually pretty unusual in my experience that those clauses would include a pandemic. So one of the things that we're certainly encouraging all businesses, including all our clients that are in higher education, to do is, look at your contracts, whether that's, contracts you've designed, whether those are contracts with a wide range of vendors, with food service, career service, any contract you've got with any third party outside the institution, you should be evaluating those clauses and determining whether or not a pandemic now or in the future, if you need to revise those clauses, would cover a pandemic, and I would revise them to very explicitly say that a pandemic is included under the sort of the force majeure clause. So that's a good idea. So I've had lots of conversations in the last few days and about what different schools are doing, and I think one of the things we struggle with here is, in terms of like when we do a webinar, we talk about higher education, but higher education includes everything from Ohio State to Miss Betty's Beauty Academy. And obviously the responses from those different types of post-secondary institutions are going to be radically different because they've got radically different types of problems and systems and facilities. We are seeing a lot of traditional higher ed, large, sophisticated institutions. Scott, you've made reference to, having your response team and so big institutions that have the challenges that come with being big, but the luxury of having those types of units are thinking in that way. Some of them have just closed down. They already had spring breaks scheduled and said just don't come back. A lot of them, if they don't have complete online capability, are working towards online capability. And when you have programming that is largely lecture-based, that works pretty well. You've got a different class of programs and institutions that have heavy clinical components, right, to their programming. I'm seeing a lot of medical schools, nursing schools, folks in the health services industry actually thinking about staying open and keeping clinics open for a couple of reasons. One is they seem to feel like they have an obligation to be open so that they can be a part of
the public health response.
Correct. Also, they have protocols in place, many of them to deal with a wide range of diseases and conditions, some of which are, I don't want to compare one disease against another, but let's just say, AIDS, Hep B, C, tuberculosis, these are all very serious things too. And they have protocols in place to try to manage those types of, diseases and conditions, and they think many of them that they're appropriate here as well. And then you have, I'll say sort of among the career schools of the world, community colleges, technical schools, and others where they have programs that have very significant clinical components, whether it's a culinary school or a truck driving school or an HVAC program that really cannot be transitioned online or may not be from a regulatory standpoint. They may not be allowed to offer those online. Usually those kinds of programs have a lecture component as well, and I've seen schools thinking about whether or not, our next term was supposed to be in the kitchen, but can we switch things around so we can do the lecture term next, and we can do that online or remotely, and then we can push that clinical component out for a term or two, and that way, because it's all about limiting contact, right? And I've seen folks talking about, is there a way if we think we have something occur in a certain program, if it's in one building, isolation concepts, right? Could we quarantine that building or just shut down that program while we kept other things going? The other thing I'll mention is even if you have a program or a school where you have a clinical component that doesn't lend itself to just sending everyone home, you still may be able to send certain people home or keep them home. So do you have administrative staff that can work remotely, even if some people will need to be present for instruction? So they're really trying to evaluate the extent to which there's any component of the institution or organization that could work online, whether there are programs that can be reorganized so that clinical components can be pushed out. But at the end of the day, there are going to be a lot of institutions, I'm sure, that decide, we just want to shut everything down. And that may mean postponing those clinical components and relationships and internships and externships for some period of time. And that's a hard thing, and you're going to have to look at those internship and externship agreements, et cetera, and just work through it as best you can. But, Scott, you made the point, Kelly, Amy, everybody has. I mean, it's not a one-size-fits-all situation, and you're just going to have to look at the options that are present for you. I have one other point I'll make, and then I'll be quiet. And it is this. I work with institutions all the time. I know, Scott, you've been in-house, worked with schools for years. And, institutions are not just in this context, but daily presented with issues of health and safety. So, whether it's COVID-19 or whether it's, sort of the natural disaster, the tornado, the flooding, whether it's a student who has threatened the campus or, God forbid, an active shooter or something like that, it happens. And my response when I get these questions, and I'm a regulatory attorney, right? So I'm a guy who's always looking at the regs. But the first thing I always say is, look, prioritize the health and safety of your faculty, staff, and students in your community, and worry about the regulations second. Because, my concern is that schools may hesitate to do the right thing, not because they don't know what the right thing is, but because they have some sort of concern about a regulatory hang-up. And I would just tell you, every day of the week, you would rather take care of people and then deal with the regulator as opposed to the other option, which is, having something unfortunate happen to a member of your community and then having to explain that you might have been able to prevent it, but for wanting to comply with a statute or a regulation. So please prioritize health and safety first, and you can figure out things with your accreditor or your regulator second.
All right, so I think we will pause for a second and take any questions through the question widget. Q&A widget. All right, so the question is, our students are concerned about regulations pertaining to online learning that many universities are switching to. Should the 3.9 CDP memo be read to mean that online instruction is approved for foreign national students? I think it reads that they are going to tolerate a level of online instruction that they didn't before. And I don't, at least at this point, there has not been a follow-up Q&A from them about the exact extent of the tolerance, but clearly they could have put out a message that said, no, we do not tolerate online instruction for foreign exchange, for foreign national students. They didn't. Instead, they put out one that said, tell us what your operational changes are within 10 days of the decision. And I think that greatly reflects their making it up as they go along here too, right? They've never had to deal with a pandemic and F1 students. And so the guidance on Monday, first and foremost, recognizes that this is uncharted territory, that there is a way to notify them of a change you have to make, and that they're going to, tolerate it for right now and stay tuned for further instructions.
All right.
Anybody else?
This coronavirus stuff is easier than we thought.
Yeah.
Very good. Very good. Well, onward and upward. So maybe we can get to a little of the originally planned content here.
Great. All right. So in the 10 or 15 minutes we have left, we are probably not going to cover all 65 slides, but we'll do a best of maybe of the remaining topics. So as an immigration lawyer in 2020, H-1B law and regulation is at the top of mind and at the top of almost all the conversations I have, including many with institutions of higher education who are facing a stricter scrutiny, along with all employers, of their H-1B petitions. And it is relevant to note that really the law and regs on H-1B petitions have not changed, but the policies involving them have undergone kind of a radical change in the past couple of years, particularly since the BAHA, Buy American, Hire American executive order. In the wake of Baja, we have seen the rescission of policy memorandum on issues like, do you give discretion from earlier decisions? And with the in the past, USCIS would often defer to earlier decisions involving the same employer and employee and job. And now that doesn't happen anymore. So it is quite common to have a scientist or a professor who you have sponsored in the past very successfully in H-1B status be RFE'd and have to send additional information to immigration to extend that status. So as an immigration lawyer, the question that I get asked is, well, is this a good H-1B? And to be a good H-1B, the job, the person, the situation, the adjudication has to be predictable, the case needs to be approvable, and it needs to also be satisfying, meaning the time, cost, and end results will meet the needs of everyone involved. And that has clearly is harder now than it has been in the past. And this chart is teeny tiny on the slide, but it's available on the USCIS website, and it is basically 5 years of RFE and denial rates in the H-1B program. And if you are an institution that files your own H-1B or H-1Bs or files any H-1Bs, you will have noticed the uptick in requests for evidence, and also the uptick in denials. And if you go to this chart online, you will see that your feelings that you have about that are actually being backed up by a lot of statistical information. And there have been times in the last couple of years when we have seen almost a 60% rate of requests for evidence, which means any H-1B you send in is more likely than not to have a request for evidence sent out on it. And previously, those rates would have been more like 15% or 12%. And in that gap is why things feel harder. This is the definition of a specialty occupation. We often tell clients the best H-1Bs are the ones for a position that requires a specialized, at least a bachelor's degree in a specialized field, and the individual has that specialized degree. The regulations lay out the 4 ways you prove that, but in the end, this is the math that gets you to predictable, approvable H-1B success. The job has to have the requirement of at least a bachelor's degree in a specialized field. The duties have to require that specialized degree, and the individual's credentials and coursework have to support it as well. When all those 3 things add up, you end up with your best chance of success on an H-1B. So we are all in this arena trying to draft more robust H-1B petitions, and we do this with more detailed job descriptions, really getting into what the nitty and gritty of the theoretical and practical knowledge is, by really clearly articulating links between the degree requirements and the duties, by including lots of comparisons between what the OOH and the ONET, which are both publications of the Department of Labor, say a job does, and what the job that's the basis of the H-1B involves. And we are being very careful and very vigilant about multidisciplinary or cross-disciplinary positions. I think this is an area where higher education is particularly vulnerable for RFE, because what we know is that it's our colleges and universities that are pushing the very limits of what we know, and often that occurs in cross-disciplinary areas. Whether it's bioinformatics and making sure you can explain why a degree in biology or computer science is relevant for that position. There is a tendency at USCIS right now to challenge how can a job be specialized if you could be either a biologist or a computer scientist to do it? And those shouldn't be, those are winnable cases. They should be successful in the end, but it does take a higher level of kind of care and feeding and tending than we've done in the past. Data analytics is hugely on the rise, and we can tell that from our panel of cases. 10 years ago, no one was involved with data analytics, and now it is a huge field that involves math and computers and often business. And the fact that it's those three areas coming together, data analytics jobs that require degrees in business or math or computers should qualify for H-1Bs, but you can expect it to be kind of a higher climb to get there. And even kind of traditional jobs like lab manager, we have seen higher scrutiny because of the M word, manager. Does a lab manager have to have a master's degree in biology or a PhD? Probably so. They're running a highly complex, laboratory situation. But there are instances where there's pushback from the agency about, well, are managers really H-1B level positions? So we deal with all of those challenges by kind of digging back to the reg and to what immigration says we need to prove that it's an H-1B. One of the four things you can show, any of the four, is that a bachelor's degree or higher or its equivalent is normally required for entry into the position. Immigration's favorite source of determining what's normal is the Occupation Outlook Handbook. That's a Department of Labor publication. But also we use the ONET, we use Job Zones, we use other DOL publications. If you go on the DOL and search for data analytics, you actually can find a lot of information of the Department of Labor saying how specialized that field is. We look to industry practice. This is a place where if you're getting challenged on whether a lab manager is a specialized knowledge position, you look to your colleagues at other universities and other laboratories, and you collect letters from them about how they've reviewed the job description and it's consistent with their lab managers at their university. Associations can provide really relevant and good information about what the requirements for a specific job are. And, also we use job postings, Googling, using LinkedIn to find out how other universities, what the requirements for similar comparable jobs are. One of the ways you prove that an H-1B is required is that it's normally required for this particular position, which means this prong of the definition often feels the most invasive because you end up providing a lot of information about other people who are working for you, which may or may not be a violation of other policies, but it is not uncommon to put together a chart of who held the job before, who holds it now, and confirm what their degrees are. We do that sometimes through publicly available information like LinkedIn and printing off the LinkedIn profiles of the other people who work in a particular department or lab or project. And we have been writing great in helping to draft just really specialized, complex job descriptions. In the old days, you could describe a job in a paragraph, and that was absolutely appropriate. And now we are asking clients to really dig in duty by duty, task by task, about what the theoretical knowledge and practical expertise is required to do a job. This is teeny on the slide, but is intended to show just the amount of information that we are providing now in university support letters or employer support letters to show just really job duty by duty what you need to have to, education-wise, to perform the duty. We do it sometimes course by course, laying out the exact courses that a individual has taken. Sometimes we have the individual sign an affidavit explaining how all of those courses relate to their work, or a professor at their school. And the next couple slides, we don't need to talk through, but they are sort of our best of citations to either AAO decisions or federal district court decisions about issues about specialty occupation and H-1Bs, which we put in our letters to demonstrate just what the H-1B requirements are intended to be, to keep everyone on the straight and narrow. For the interest of time, we just hit an hour, so we're going to cut it off and probably take this up again another time.
If I can talk you into maybe coming back later in the year here, we can hit on some of these other topics and circle back around to them, because I know that immigration is a for a lot of our clients is something that they're working through all the time. Now let's see. We should check real quick and see if we had any other questions come in. And then you can hit the down at the bottom there. There you go. There, perfect. And then if you guys will scroll down, let's just see if we had any questions here towards the end that came in. I think we're clear on questions. So with that, we'll go, and there you see Kelly and Amy and the lovely visages on the screen that you can check out. That's,
there's you.
Yeah, that's my impression of man auditioning for local production of Dead Poet Society. And then we'll leave it with our disclaimer here at the end. Hey, we always appreciate everybody tuning in. We know, particularly around the coronavirus topic, boy, as we've said it several times, but it's just all moving so quickly. Do the best you can. If you want to reach out and chat with us, you're always welcome to do that. Chat with your counsel. Keep an eye on the regulators and their announcements. And also, to the extent you have trade associations, those of you who may be members of NACUA or NACUBO or CQ or any of those fine organizations, I'd keep an eye out on what they're putting out too, because some of them have the perspective of talking with lots of different folks that they represent. And remember, next couple of months we've got intellectual property and cannabis and higher education. So I hope you'll tune in for those as well. Have a great afternoon, everybody, and we'll see you next time.